Hi, I'm Farrah from prosperlaw. I'm going to talk to you today about consultancy agreements for architects and engineers. It also broadly applies across other design and consulting disciplines. As an architect or an engineer, your consultancy agreement is the most important document you'll sign. Why? Because it sets out the rules for how you'll work, how you'll get paid, and exactly what you're doing in exchange for that money. As a lawyer, I often deal with the legal terms in the consultancy agreements, but one piece of the contract that I always see fall down or often is the scope of services. Scope creep can cost you time and money, and often the people looking at the scope are technically on point, but they might not have a broader understanding of how the contract interacts with that scope of work. There are often clauses in the contract itself and not in the scope of work, which requires engineers and architects to essentially do work for free. So it could be things like value engineering, where you have to keep redesigning to meet the client's budget, which might be changing throughout the life of the project. You could also be required to fix other consultants' mistakes at your own cost. Another key point in consultancy agreements that is often overlooked is the intellectual property clause. So if you don't know your client very well, or they have a history of not paying on time, using the IP clause as leverage to get payment is a really powerful tool. So it could be as simple as saying they don't have any IP rights unless and until you get paid. I often see the technical team at architects and engineers either not read the variation clause, not have an understanding of how it works, or they do and the variation clause is drafted terribly. It's really important to pay attention to timing requirements, how the variation is to be communicated, and make sure that you don't start work on the variation until you've agreed with your client that it is a variation and how much you'll get paid. And obviously a key legal focus for me is indemnity clauses, limits of liability, and consequential loss exclusions as well. They basically protect you if everything goes south. You've got some rigid contractual limits on your liability. It's also really important to make sure that from a legal risk perspective and also your scope, that you're only assuming responsibility for things that are within your control and also within your area of discipline. The bottom line is a well-drafted consultancy agreement appropriately balances risk between you and your client. If you'd like to learn more about our services for architects and engineers, please click on the links below or visit us at prosperlaw.